Dr. Filescu.
Thank you for the kind introduction, Lee. Let's get to it here. If you're starting a DPC practice, what are all the legal questions you need to ask? We'll get into all the big stuff, mostly federal, some state as well. Okay, so outline, we're going to do contracting. We're going to discuss how to do that with insurance companies, hopefully not, mainly how to get out of them. What you want to look for with a contract with a patient, with large employers, with some sort of vendor and consultant, what are they going to want from you? The difference between a pure and a hybrid practice and how you can legally set up those different operations. And then it's sort of a general compliance view, including the Affordable Care Act. And do you want to be a DPC physician is sort of the first question. Most people here are either considering it or already doing it to some degree, but you need to make sure that you're actually ready for it. So we don't say that quite enough. You hear a lot of pomp and circumstance, but just be frank with yourself. So if you're going to do this, you can't be hidden. That's one thing family physicians can do in a large hospital system is they can sort of be hidden and not necessarily work as hard. You can just refer everything out. Nobody really figures out that you're being lazy and not working things up like you could. If you're DPC, nobody can hide you here. That's actually, I'm a Kentucky basketball fan, so that's a John Calipari quote. He says, I can't hide you here. Everybody's going to see how you're doing, and that's how it is in DPC. You have your standard small business burdens, and a lot of the questions we get, or a lot of questions I get, are actually not really DPC specific. They're just standard questions related to any small business in the United States, which is harder to form than it used to be. Are you comfortable charging for your time? If you talk to the guys at Hint, they'll say that was one of the most popular survey questions in terms of predicting success for any number of DPC practices. So let's move on here. That's a little bit about my background. That's where I do a lot of my work, up in Torrington, on-site DPC. So my first week as a DPC doctor, I realized I was going to be doing this on a regular basis. It's a paracentesis kit. So you really do have to broaden your scope and be ready for a lot of different things. Understand the difference between DPC and concierge. Concierge really does not have a legal definition. So that's the first thing to say if anybody starts to nitpick the words with you. But DPC is defined in the ACA and now in 23 states, plus several more that we anticipate over the next few years. Concierge usually means a fee for non-covered services practice, which means you're still billing traditional insurance, and then you're charging some non-covered services fee for everything that's over and above that amount. And insurance companies hate it, and while it's good care for the patients that can't afford it, it really doesn't lower the overhead and make the big difference DPC does. Do you want to be independent, which is most of the docs at this conference for sure. Definitely most of the practices in the MAPA are totally independent. Some are also members of various networks or even in employed roles, especially on-site DPC, like where I spend most of my time. Okay. If you want somebody to handhold things and do everything for you, don't go independent. That won't work out. You have to be sort of motivated and entrepreneurial to do that. If you're intimidated by all the small business issues, then look at other employed roles. So DPC pure versus hybrid. You've got some cash flow considerations to look at. Do you want to do it immediately? Do you want to have a lights on, lights off? Do you want to gradually transition out? And if you're going to transition, how do you do that? The most common questions I get are Medicare moonlighting related questions. Folks want to go all DPC, but they still want to have some sort of part-time role. And how do you do that if you're going to opt out of Medicare and truly open your practice up to every patient? So we'll get into some of that too. Patient panel predictions. Who do you think is actually going to join? Panel sizes tend to mirror the age of the physician. So if you're older, you're going to have more Medicare patients than if you're younger typically. And maybe your motivation to opt out is higher because you've already worked in the community, you've got some money saved up. So that's what I tend to see is the youngest physicians don't necessarily opt out right away. They don't have the savings. Their panel size doesn't reflect that group. So they build a wait list and then do it. And who's actually price sensitive? Because those are the patients that are going to sign up. The higher the deductible, the better. The less insured, the easier it is to grow your practice typically. So if you're dealing with an insurance company contract, remember that you can actually do whatever you want, theoretically. Whether or not they'll actually play ball and change the terms depends on who you're talking to. Usually they won't. But this is not like Medicare, this is not like Medicaid. You could come up with whatever customized agreement you both agreed to. So that's the notion of freedom of contract, that's that top bullet point there. So if you're gonna play games with them, the easiest way to do it is to use different LLCs, which is the second bullet point. Why would you want one? That's if you wanna have some practice or some role, maybe a traditional urgent care site, and you would sign an agreement with that insurance company, but it would be at the LLC level, not the individual physician level. And that gives you the flexibility to do what you want with your other LLC or with you as an individual physician. If you sign a contract with the insurer and it's at the physician level, they're obviously going to come after you when they realize you're charging their patients cash pay rates at your own clinic. There's a high-tech exception to that, but that's a little clunky to do every time to make the argument that every single one of your patients wants that privacy level. Inpatient only or outpatient. So a lot of folks want to maintain some sort of hospitalist role. You can do that. You can have the insurance company sign contracts with the hospital rather than with you, and then it's at the entity level there and sort of gets you out of them having any say in your private practice as well. But Medicare, that really won't work unless you just don't want to bill when you're in the hospital, in which case, as an opted-out physician, you could still rotate through the hospital and not charge for your services, but the hospital gets paid for all the things you order. So they don't usually mind too much since you're the one taking the hit. Okay, what old non-competes are in place and what does your state say about that? There's a lot of state variance when it comes to physician non-compete laws. Some states really don't enforce them much at all. Others are pretty aggressive. Kentucky will enforce them pretty aggressively. Texas, they're not so bad. So there's some case law, some places that you can rely on. If you're trying to get out of a non-compete, the more narrowly tailored its design, the more enforceable it becomes. And that's almost regardless of which state you are. So I usually don't see them broader than a 60-mile geographic radius. They're usually tailored to whatever you were doing. So they might say something like family medicine outpatient, or they might say hospitalist, or whatever role it was. If they reduce that to urgent care 10 miles, it's much more enforceable than if they say all primary care 100 miles. Often the nature of your election to go DPC gives you an argument that, hey, I'm not doing what I was doing with you, this is not competitive to you, you don't have a DPC practice, that wasn't contemplated in our agreement, and you can usually find a way to get out of the non-compete. Most non-competes are written to be more intimidating than enforceable, so if that's the reason you're not doing this, I would advise you to really look closely at it because there's a good chance you can get out of it. You do want to give them your notice of termination. That's with either an employer or an insurance company. There have been folks that just didn't pay attention to that and tried to do a lights on, lights off switch, and then everything got delayed. Okay, yesterday we kind of got into this already as far as state law. Look at, hopefully you have DPC law in the books. If you don't, start with your insurance code and go from there. Most of those are linked on the state's pages on DPC Frontier to make that investigation a little bit easier. Scope, you want to define it as precisely as you can. It just clarifies everything for your patients, for the insurance commissioner. It clears up expectations. Billing is easier if you do it in arrears in terms of appeasing insurance commissioners, especially in states without a law. What does that mean? That means after the fact rather than before the fact. If you bill, there are plenty of DPC practices, especially the older ones, that like to bill everything up front for the entire year. I don't like that. In some states, that would create an escrow obligation, so you wouldn't necessarily have all the money right away anyway because you have to have the ability to refund some of it. What if they move? What if they die? What if whatever? Even if you try to make that non-refundable, there are situations where you would need to pay it back. So if you want money up front, don't do it with your monthly fee, do it with an enrollment fee. Because when you label it that way and describe it appropriately, that's clearly non-refundable. Everybody understands that. That's something you can move up and down easily based on volume too. Maybe you're day one and you want everybody to join, so the enrollment fee is $10. Then you're overwhelmed after 2 months because too many people have signed up, so you up the enrollment fee to $150 or something. And the whole time your monthly fee stayed the same, so you haven't made people mad. So that's an easier way to do it mechanically, and it's clear to everybody. Disclosures, tell people that you're not insurance. That's to go without saying after all our discussion so far, but that needs to be in the contract. That should be in your marketing materials ideally. And any kind of status you have that you want to disclose to them as well. If you haven't opted out of Medicare and you're not opening your practice to Medicare patients, then there needs to be some provision in that contract where they're initialing and telling you they're not Medicare. Because they can show up and be 35 and be on Medicare, right? Everybody forgets that. If they're on disability, if they've got end-stage renal disease, there's some exceptions you need to be aware of, so you can't just do it based on age. Clear terms about what activates the membership and what terminates it. If you're working with a membership management platform that wants you to have everybody sign up online and start instantly paying you, does anybody see a problem with that? What's going to happen? They're going to sign up and pay you for 2 or 3 months, and then they're going to show up and they're going to ask for a bunch of things you may or may not be comfortable doing, and now you've got a patient abandonment problem because you've already established a patient relationship, you've already taken payment, and at that point refunding it and arguing you're not their doc is much harder than if they came in day one and you never really took money. So don't take any money from the patient until you're sure you want them to be your patient, which for most people means they need to come in your office. If you're transitioning a practice and you already know the people, then that's easier. Okay. Emphasize that this is for ongoing primary care, not urgent care, not as-needed visits. That's where the value is. That's where the money savings is. Maybe your younger patients won't get that, but your older patients certainly will, and it's going to make the insurance commissioner happy when they realize that's what it's for. When the IRS wakes up and views this the appropriate way, they'll also realize this is for ongoing chronic primary care. Clarify that it's not an emergency and have the patient initial this. So I found this provision looking at a lot of Medicare opt-out regs, but it's good for anybody because you can't sign a contract and have it be enforceable if it's under duress. And if your patient storms in day one and has crushing chest pain radiating to the left side, then you probably can't enforce whatever agreement you're going to try and put in, right? So you wouldn't do it in that situation. It sounds silly, but you want to make sure there's no emergency when you're agreeing to these things. No expectation that you're going to file third-party claims. Some practices get themselves in trouble by saying our fees are ultimately going to be reimbursable by insurance, even though we're out of network. This will all apply toward your out-of-network deductible. Don't say that because you don't know if it's going to be true. It's going to create a lot of headaches when people come back asking you to fill out these forms that you wanted out of in the first place. I've seen a few DPC websites that said, become a member of my practice and you get out of the Affordable Care Act tax. Totally bogus. Don't know where that started. People confuse us with health shares. Health sharing ministries will get you out of the tax, but DPC alone will not. The provision for DPC in the Affordable Care Act we'll get into later. It was designed to work with something called a WRAP plan, and those two things together could get you out of the tax, but DPC by itself is not an exception. Going to prison is an exception. So that could be an option too. I'm enrolling voluntarily. That kind of fits with some of the above statements just in terms of making the agreement enforceable. One of the other things you could reference, I don't have it in here because I'm still digging into this myself, but there's actually a Federal Arbitration Act. There's some physicians who've sort of thought about it and decided that might lower their legal fees in the event they were to have a malpractice case. And those have been appealed to the Supreme Court at several different state levels, and they've been enforced. So in the event of litigation, you can opt for arbitration rather than the traditional process, which lowers your legal fees and moves things along quicker. So that's something else you could sort of throw in the contract, and it's been held to be enforceable. You want the agreement to be non-transferable. They can't pass it along to another patient. You get to decide who you accept into your practice. And for any complaints, you want to hear about it first. And then the medical board, I suppose, is the entity that should really hear about it ultimately. And you don't want any of that going to the insurance commissioner since they shouldn't have any jurisdiction over your practice. And most of the time, we're going to have some sort of clause in there. Depending on what you do, it might be different. But if you're a DPC doc, you already have people looking at you because you're weird, you're different. And if it looks like it's some sort of cash pay for opioid practice, you're in trouble. So just be careful with that. Contracting with employers. Employers have different expectations. If they're a small employer, 50 or less, maybe 100 or less, they'll probably let you do exactly what you want. They're just going to steer their patients your direction, likely because you had a personal relationship with the CFO, CEO, et cetera, and that's fine. That's easy. That's just an addition to your practice. If they're much larger, say 500 or more, they're going to expect a lot of data. There's going to be a broker who you've got to be involved in discussing things with. There's going to be a third-party administrator, a TPA, who hopefully is as wise as Jay Kimpton, but that probably won't be the case. And you have to educate all these folks. And it becomes pretty complicated pretty quickly. You have to be able to aggregate the data and prove that you're saving money, and in so doing, you erode a little bit of your own efficiency to acquire it, but you have to do it in a way that's meaningful. So that it says charge a PMPM, not a PEPM. So plain English, that's a per member per month, which is kind of what we're all doing right now, as opposed to a PEPM, which is a per enrollee per month. The difference being, if you're paid for everybody up front and you haven't actually seen them, then you create some potential problems for a lot of ways. One, you're not going to make a difference in the cost of care for the employer. Two, you have patient relationships with folks that you might not have an agreement with, or you might not want to have an agreement with, I should say. So retain the ability to reject or accept patients just like you always would. You have to have the ability to hire and fire. They have to have the ability to select you or to select whatever other plans their employer might have. Otherwise, you become an arranged marriage rather than a selected marriage, which is more like old-style capitation. So patients should still get an individual contract no matter who's paying the bill, if it's grandma, if it's the employer, either way. Okay, so the large employers that tend to adopt this do what's called stop-loss plans typically, so you can think of that like an aggregate plan for the employer, where if they're comfortable with $600,000 going out of their bank account, they can just afford to pay that. Then what they do is they save some money on their insurance by going to Blue Cross or Aetna or Cigna or whoever they want to work with, and they say, for this first $500,000 in claims, I'm going to be paying the checks. I want to have access to your network and your negotiated prices, which they think are good and are bogus, but I'm going to pay the claims. The TPA, the third-party administrator, is going to pass those on to me, and until I hit this threshold, this stop-loss threshold, it's all coming out of my pocket. Why does that matter? Because if they're not on a stop-loss policy, they're less interested in DPC because it's purely a quality pitch and not a cost-savings pitch. Does everybody follow that? So if you don't have a stop-loss policy, all that money you've saved by doing a good job, by paying attention to price transparency, that goes to the insurance company. If the stop-loss policy is in place, then the money that's saved goes to the employer. So they're more interested in it, obviously, if it's their money. Okay. And the small employer piece, we got into that yesterday. There's a 4980D provision that was kind of confusing folks. There's technically that $100 per day excise tax that's on the books, but that's a per day per employee fine for offering less than a full plan. But there were exceptions that were passed to that in the Cures Act that essentially swallowed the rule. So that really shouldn't be a problem anymore. Okay, if you're working with a consultant, and they will show up, if they see that you're a DPC practice and they've heard about this, they'll try and find you and maybe send you some patients from an employer. Be very careful what you do and what you agree to. I would not pay them. They're already getting paid by most of the people they interact with. They don't need to get paid by you. It creates conflicts of interest. It may well be illegal, depending on how you structure the agreement. It could amount to what we call unlawful fee splitting. If you're a physician and you're splitting your monthly fees with somebody else, they had better be a physician too, or you better come up with some way to make them a part-time employee or something else if you're going to find a way to do that. And that's in any professional sector. It's the same thing with attorneys. And you've got weird quirks in the law where you can have attorneys can pay other attorneys referral fees, but if a non-attorney sent them a patient or sent them a client in that case, then they couldn't. So we've got similar things in medicine that you want to be aware of. If you're getting large quickly, then you need to be aware of whatever the corporate practice of medicine laws are in your state too, that kind of thing. And ask them about actual DPC experience. A lot of folks will claim to have it, and you start talking to them more, and you find out maybe they don't really know what DPC is. Maybe they come out of the concierge space or some other sort of cash pay style, and they think this is the same, and it's really not. If a vendor's talking to you, and they say we are HIPAA compliant, what does that mean? Nothing. There's no HIPAA certification. There's nobody handing out a compliance sticker. It's just marketing. So HIPAA was written to be nebulous. It was poorly worded because it was spark notes that got passed into law by a committee the third year in a row after nobody ever did anything like they were supposed to. There's no certification. There's no formal process. It's gray, and it's gray on purpose. Your obligations under HIPAA vary with the size of your practice. The main thing you need to remember about HIPAA, I've got a page on DPC Frontier that sort of lists out the requirements of it, but you want to be able to prove to the government that every year you sit down for a little bit at least, maybe an hour or two, and thought about security and privacy. And you want to make notes of what your thoughts are on that, why you're doing X, Y, and Z. So in your contract with your patient, for example, you might say to them, hey, you can text me, hey, you can email me, you can call me, you can do all these different ways to get a hold of me, and then maybe you list a preferred hierarchy. This is more secure than this is more secure than this. So it's your choice what you want to use. There are applications here like Spruce that have clearly taken security seriously, and a message that goes through their platform that's protected is more protected than an SMS or text message. So make sure patients understand what these levels of preferred communication are, and just make evidence to the government that you've taken privacy seriously. So which services actually secure protected health information? Where is your BAA? BAA is Business Associate Agreement. That you want to have with any vendor. So just to scare everybody in the room, I'll prove that we aren't doing this the way we're supposed to already. But so if you're working with an accountant or attorney, you're almost always going to have a BAA, and they're going to be smart enough generally to ask for it, even if you didn't necessarily remember. But technically, anytime you share information electronically, you're supposed to have a BAA. So can anybody think of something that where we're all breaking that rule on a regular basis? Do you have a BAA with every pharmacy you work with? But you probably should. So there's things here that sort of surprise people. Now, we already know the pharmacies are currently under HIPAA anyway. They're another covered entity, but you really should have a BAA in place even there. Anybody you're sharing the information with. You place yourself under HIPAA by electronically transmitting information. So if you're doing any kind of electronic claim, it's going to show up there. If you avoid all those things, you can try to build an argument that you're not under HIPAA, but I don't recommend promoting that. That's sort of a last-ditch effort if you're dealing with some sort of legal case and you're trying to defend yourself. So there is a way to structure it that way if you need to. Okay. So all these are vendor questions. That's just sort of for your reference. Medicare opt-out considerations. If you want to be open to all ages and not worry about any kind of hassles in terms of False Claims Act, Stark, certain antitrust at the federal level, anti-kickback, then it's really helpful because it gets you out from under all those things. The only reason, and this is this room or elsewhere, and this is an important distinction, the only reason to opt out of Medicare is so that you can see a Medicare patient under private contract. And our politicians need to hear that as much as anybody, because people view this opting out of Medicare, it becomes political, it becomes, why would you do this, why would you, it sounds like you don't want to see Medicare patients, and it's precisely the opposite, right? You're doing this so that you can see them and not charge the government. So why does the government hate that? I'm not sure. But that's what you're doing. That's the only reason to do it. If you're simply not going to see them right away, then you're not going to open your practice to them. Because the easy retort to sort of prove that is you can pull up the opt-out list. This is all public. And one of the largest groups that's been opting out for years actually is psychiatry. Guess which group's least likely to opt out? Pediatrics. Because they, how many Medicare patients are they seeing? Just a handful with maybe end-stage renal disease. So I don't know any kids on disability yet. So other than that very small group, they just don't see Medicare patients. So there's no need for them to generally even contemplate opting out. So if you can't do that yet, then you have other decisions. Are you going to be hybrid? Are you going to be a fee for non-covered services practice, or simply not open to Medicare patients right away? And that last option is what most folks choose. If you've opted out and you want to work in other settings, where can you do it? And they're listed right there. So there's the one I do, which is next to the bottom, the correctional prison medicine, which is on-site DPC in a weird way. There's hospice, which is administrative roles. If you're not actually seeing the patient, doing patient encounters, then it doesn't matter that you've opted out there. Workers' comp is typically a state-based insurance system that's paid totally separate from everything else, so that's an easy one. And then you can, of course, do part-time on-site DPC work. We've got some physicians doing that. And then the first exception, which I've come back to on purpose, is oddly enough, it sounds like it'd be the largest, but it's also the most difficult. I've had conversations with hospital attorneys where they say, yes, there is a modifier for this, and yes, we could do this, we just don't want to. So usually you can't talk the ER into doing this, even though it's possible. If you were to get one to play ball, the thing you need to remember is any ER patient that shows up that happens to be a member of your practice to which you have privately contracted, you can't use this exception there. You're basically going to see them for free at that ER visit. Opt-out logistics, if you decide to do it, there's a quarterly pattern that gets a little bit confusing, and I don't think they contemplated all this confusion when they drafted the law. The windows are January 1st, April 1st, July 1st, and October 1st. They need to get your paperwork at least 30 days before those windows, and it doesn't necessarily become active until those windows hit. When most people mail it in, they mail it in with return receipt requested because they may or may not send you a form even acknowledging they have it. Fortunately, there's a list now where you could later look up your name or anybody else in this room, quite frankly, to see if they've opted out and see what their advice is on it, and you can sort of prove it that way. During that window, that 30-day window, I'm asked, what should I do? Can I still bill the patient under Medicare fee-for-service? Can I privately contract with them? I've read on this. To me, it's still unclear. So usually what I tell people is, if you're switching over to DPC and you want people to join your practice, use it as a trial month. It's probably not going to hit you too bad to just provide like 1 month of free care. Technically, you'd be obligated to do that anyway under patient abandonment laws in a lot of states. So use that to prove the model to them and see if you can't get them to join the practice. Okay. So technically, there are 3 regular statuses with Medicare. There's participating, which is what everybody in this room was defaulted into during residency. Then there's non-participating, which is a category that's almost never used in DPC to my knowledge, where you have the ability to bill Medicare slightly more than you otherwise would, but you're following that same fee-for-service schedule. And then there's opted out, which is what I've been discussing mostly, which is a mechanism Medicare came up with for you to privately contract, but they still know who you are. You still retain all your numbers. All your orders for DME, labs, referrals should all be filled because you're still credentialed in a sense with Medicare. And then there's this 4th theoretical category that can get people real confused if they start digging, and that's disenrollment. It's a legal black hole. I do not recommend doing it unless you want to have a case go to the Supreme Court for legal theory grounds. So those folks try to argue that Medicare has no jurisdiction over them. They've totally disenrolled from it. They're non-existent. And there's this Form 1490S that they actually promote to their patients. 1490S is designed to get a Medicare patient reimbursed for services provided by a physician that was unknown to Medicare. So as far as I can tell, it's used for 2 purposes. One is if you're traveling overseas, maybe you're driving through Canada on your way to Alaska and you have an emergency and you're seen by a Canadian physician, then you could fill this out and get the government to reimburse what you paid out of pocket for that, or at least part of it. And then if they try to use it domestically, I think it's just a tattletale system. If there was actually a physician in the U.S. that they filled this form out on, as far as I know, they haven't been paid, and they use that to start an investigation. So don't promote your patients to do that. When they sign an opt-out agreement, in fact, part of that process for both you and the patient is a promise that I'm not going to seek reimbursement from Medicare. The group you can play some games with once you've opted out is actually Medicare Advantage, because Medicare Advantage contracts technically cover anything that Medicare doesn't. So when you opt out, Medicare doesn't cover anything anymore. So some people have got reimbursed on a partial basis from Medicare Advantage, but again, that's not something you would advertise. Private contract terms, this should be in your opt-out agreement. A little bit of this is redundant with what we've already talked about. That's just there kind of for your reference. I can do that if anybody has questions on it. Most common advertising mistakes, I see these words on websites all the time and I always cringe. Unlimited. Nothing gets the attention of the insurance commissioner more than this bad adjective. Find some other way to describe your practice, because that's literally not true. If somebody saw you every day for 365 days, there's something very wrong. So describe things in a more accurate manner. What I usually say in the contracts I promote is, rather than saying unlimited visits, you probably put some sort of term in there that gives you an out. And you don't even have to enforce it. Maybe you say something like, the first 20 visits are at no additional charge, chronic care scheduled visit, and in the event there are more than 20 visits, I reserve the right to start charging a $25 per visit fee. Something so basic as that tends to make insurance commissioners much happier. So avoid the unlimited word because it simply isn't true. You probably want to avoid the 24/7 word unless you have a whole lot of physicians in your practice and a whole lot of cross-call, which erodes the efficiency of the DPC model, so most people aren't pursuing that. If you got in a plane and flew here, unless you paid a lot of money for a fancy airline. That probably means they couldn't call you on your way here, right? So you weren't really available 24/7. Just don't say that. Don't create that obligation. Don't create that legal argument. If you say higher quality, you better be ready to defend it. This one bid MDVIP. There was a case on that. I don't have the citation in front of me, but one of their physicians advertised on that basis, and they sort of backed it up, and then they certainly did not deliver higher quality in that medical malpractice incident, and it made things worse. So talk about more time, more care. Don't necessarily say higher quality unless you're really higher quality. Covered and utilization, those won't get you quite in as much legal trouble, but they're just bad words because we're borrowing them from insurance, which is what we don't want to be like. We don't want to look like insurance in any way, shape, or form. So if something's included within your scope, find some other word that you want to use to sort of go over that. Okay, generalized compliance overview. So the Affordable Care Act we'll get into in a minute. I should have a separate slide on that. HIPAA I've already sort of spilled the beans on. Medicaid we went over yesterday. Most states are going to have some sort of information available there. Either you have ordering, referring, and prescribing only status, or you simply don't sign up, and that's what you use to privately contract. Kentucky and Colorado are known exceptions. Florida is just fine. I put them on here because that's where we are. In Kentucky and Colorado, you cannot privately contract with Medicaid patients, full stop. In-office dispensing, we went over that yesterday. Pathology, we could discuss that. Labs, occasionally this comes up. New York and New Jersey are an issue. The other things there are CLIA and OSHA. Most people aren't used to thinking about that. If you were an employee, you just let the hospital deal with those things. OSHA's pretty simple. There's no getting out from under it, but you don't need to. You need to put a poster on the wall, do a little bit of training, tell them you're serious, and that's it. With CLIA, the thing to remember there is even if you do CLIA waived labs, CLIA still has the ability to audit you and make sure those are indeed waived labs. Where most DPC docs will get in trouble is that microscope that you have for looking for trichomonas or whatever. That technically means that you're beyond waived and you're in a different category now. So you need to be able to deal with that. If you don't want to deal with CLIA at all, then the way to get out from under it is to only order tests that are patient administered. And if you start looking around, you'll find that most of the things you're ordering actually are. So, most common things we do, maybe a urinalysis, rapid strep test, all those things can be purchased by the patient on Amazon and literally patient administered or in CVS or wherever. And if you have those tests and the patient's just sort of administering it on themselves in front of you, then you got an argument that, hey, I didn't do any labs at all. I'm not even CLIA waived, if that's something you're concerned about. Patient abandonment, pay attention to whatever your state laws are there. It's usually it's at least 30 days, sometimes a little bit longer. And you don't technically have to offer them full scope free care. Most people do that for a lot of different sort of political reasons, but you basically just have to cover emergencies. And if you weren't prescribing a lot of controlled medications or they weren't, severe hypertensive on clonidine, then you're probably not going to be in too much trouble there if they don't follow up with you much. What does the Affordable Care Act say about DPC? HHS shall permit a qualified direct primary care medical home plan that meets criteria established by the Secretary. So what the heck is that going to turn into? And then they discuss that a little bit more, and they go down and say, consistent with the program established in Washington. And they're referencing Washington State, not Washington, D.C. And so that's the DPC law that, like it or not, has more weight than any other, because that's what the Affordable Care Act referred to when they sort of contemplated DPC. I'll back up a minute because I don't have the second slide here. So what this meant was you could add DPC to a wraparound plan that specifically did not cover primary care. Those two things could be purchased side by side in the insurance exchange, and this could be together, this counts as a compliant plan. If you just had DPC, or if you just had the WRAP plan without DPC, then you don't include the 10 components that the ACA says you have to have in order to have full coverage. Does that make sense to everybody? So if I'm doing a WRAP plan, that WRAP plan is sort of illegal by itself if they don't also have DPC, because now I sold them an insurance product where primary care wasn't included. Does that make sense to everybody? So that's what the ACA discussed. You'll hear people say they have WRAP plans. To my knowledge, nobody really does. We never hit critical mass. The insurance companies didn't pay a whole lot of attention to it, so these were never really developed. What people would do is they would just buy the highest deductible plan available and sort of call it a wrap and be done. But insurance companies never took that as far as they could. HIPAA buzzwords that you want to know. Covered entity. If you electronically transmit health information in connection with one or more standard transactions, you're a covered entity. So most of that's going to be billing related. If you're a DPC and you never transmit electronic information that way, you can try to build an argument that you're not a covered entity. You're still going to be a business associate. You still want to take security seriously, and you want to advertise that to your patients that you take it seriously. In some ways, if you want to spend time educating your patients, this means things are even more private, because the P in HIPAA stands for portability, not privacy. And that can be a way that you grow your practice. I forget who it was, but one of the DPC docs in here was telling me they had several former NSA members join their practice on privacy reasons, which is kind of cool. So you can advertise that. The P in portability means you can, on a standard basis, share it for 3 big categories. Those 3 big categories are right there at the bottom: TP&O, treatment, payment, and operations. So when you were discussing cases in residency and we openly used patients' names, that's because we could. That all fell under the operations exception. When an insurance company badgers you right now for a prior auth and sends the patient's name via fax and has all this information on them, that's a payment exception. So you didn't have permission from the patients for those things, because that was all contemplated under HIPAA as automatic sharing in a sense. If you share information under HIPAA and it wasn't one of those 3 things, then you need to have permission from the patient, and you need to document that request and keep track of those things. That's called an accounting of disclosures, and you want to be able to turn that in if the patient ever asks, where all have you sent my information? So when you're doing this risk mitigation focus, as I've already mentioned, you can try to build an argument that you're not a covered entity, but I would never advertise it. And your second defense is, hey, I complied. I proved I was serious to you because I had a risk assessment, and I updated that every year, saying about password protections I use, hierarchies of information sharing, and so forth. And the rest of those are just sort of forms that you need to have in place. They're all fairly standardized and don't require a lot of customization beyond the risk assessment. Okay. The patient does have these rights under HIPAA. That's sort of there for your reference later on. The accounting of disclosures is what can catch people off guard, so that's why I specifically mentioned that. That's your list of where all you've sent their information outside of TP&O. Okay. I've had it with HIPAA. We can go back to that later. Tax law issues. These we dug into a little bit yesterday. The IRS under 223C doesn't really know where to classify this. Right now they say this smells like a gap plan. Because it smells like a gap plan, you can no longer continue to fund an HSA when you have DPC. And because they're not sure it's a qualified medical expense, because they don't understand the nature of ongoing chronic care, they say it might not be deductible under 213D, meaning you cannot spend HSA money on DPC. If you manage to make DPC look like cash pay fee for service, both of these problems disappear. But doing so is a little bit clunky. So the way you can do that, you can mirror what surgery does with their 90-day global fee. So maybe you bill the patient every 3 months, they come in, you have some sort of visit with them, either in person or telemed or whatever. Maybe you're renewing their prescriptions that you're dispensing in the office, and they physically see you and they pay you at that time. Then that looks like, okay, a fee for service visit on a regular basis. And then they had ongoing included chronic care follow-up with that, just like they would have if they had a surgery performed. So that doesn't seem to get the same level of attention. The thing you have to remember with that is you still need to itemize everything so that they could use their HSA for it cleanly, and you also want to pay attention to where they are in their payment scheme, if you will. So if I remember the number off the top of my head, I think for an individual it was 1,300 maybe, or 1,700 that your deductible has to be in order to qualify for an HSA. You could monitor things, and until they hit that amount, whether it was money paid to your practice or money paid elsewhere in the system, and once they've hit it, you could switch them over to monthly like everybody else. Does that make sense, or did I totally lose everybody? Yeah. So it's a mess. But long story short, let's make it even simpler. If you have a patient who has an HSA and they're worried about this and they discussed it with their accountant, which is the first thing you should say, just discuss it with your accountant. It's their risk, it's not your risk. If they conclude it's a problem, then give them something like DPC and charge them on a fee-for-service basis. That solves your problem. If it's cash pay fee-for-service, nobody's going to bother you. So you have to find a way that accurately represents your time and something that they agree to. But all those labs that were itemized all along, all those medications that were itemized, you never had a 213D problem there. They can already clearly count that as a medical expense. And when your service appears to be cash pay fee-for-service, it fits in that same category, and you also get rid of the gap plan issue. So that's the easy solution for the HSA patients that are concerned. Where this becomes a real problem isn't your one-on-one patients. They sort of get it or they don't. It's with large employers, because they're not funding one HSA, they're funding 10,000. And this becomes a really big risk and a really big hassle. Health reimbursement arrangements are generally okay. Okay, so here, sort of prompt our Q&A a bit here. Hospital says they will not let me work in their ER when I opt out. What can I do? You can educate them and cross your fingers. You can't force them to do that. If you had a local urgent care, you're probably more likely to educate them into making this an option. Patient has threatened to report me to the medical board. What do you do? So you prepare your defense and you deal with it. It's not the end of the world. Everybody's used to panicking on these things. It's probably going to happen to you at some point. And when it happens, just make sure you have all your paperwork there. Make sure you didn't violate your notice provisions in your own contract with them in terms of terminating care, and that if you had any kind of obligation, typically 30 days, you fulfilled it. So the instinct there a lot of times, and I mention that specifically because I've seen physicians, they get reported, and what do? They take it personal, which is understandable, and they want nothing to do with the patient, right? About the only thing they're going to do is maybe send their records somewhere else, and you can compound the problem if you had a 30-day obligation to them and you found out about it. Okay. What if the hospital refuses privileges? That can happen. They do that based on board certification now, and it's permissible in most states. So if they get mad at you because you're DPC, you got to be aware of that, be aware of the politics at play. If you're not using your hospital privileges, if you're just sort of letting them sit there, I would usually say go ahead and get rid of them, because having privileges gives them leverage over you. If there was some sort of political fight that develops, now they can report you to the National Practitioner Data Bank and try and make your life a little more miserable. If they don't have privileges, they have no jurisdiction to bother you or say anything to you. Non-compete we already covered. Can I get out of the ACA tax by just signing up with your practice? No, good. I can't come in to pick up my meds. Will you just mail them to my house? No, why not? Because you're not a pharmacy, right? They have to pick it up in person. A lot of states, the physician has to physically hand it to them. Don't get into the business of competing with pharmacies or you can get yourself in trouble. Will you code this as an annual physical and let me bill my insurance? No, bad idea. Will you swipe my HSA card? It's up to them. So you're not in trouble for that. I just want to make that clear to everybody in this room. That's a risk they're taking. That's an opinion they're making. So I'm not going to tell you to say yes or no. That's kind of a trick question. I want you to intentionally tell them, talk to their accountant. There's advice out there. I'm not telling you what to do on a tax basis. So all kinds of HSA cards are being used right now, and there hasn't been much enforcement of it. So that's a calculated risk on their decision. That's a tax position. Will you fill out this prior authorization form? That's your call. There's different approaches to that. If you want to see one of my favorite approaches, Google Greg Zydiak, Z-Y-D-I-A-K. I've got it highlighted on DPC Frontier too, but he has the best way of dealing with prior auths I've ever heard. He faxes them a legal case telling them they're obligated to pay him for their own nonsense and their own administrative problems, that this has nothing to do with patient care, and he's right. And usually what will happen is they'll back off, and he doesn't have to fill out very many prior auths anymore because they just approve everything. They don't actually pay him, but they stop bothering him with them. Because when I got a prior auth for Zyrtec in residency, I just about lost it. Okay, what if the patient asks, I'm traveling out of state next week, can we just keep our follow-up appointment via telemed? Yeah, right? What's the key word there? Follow-up. You can't establish a patient relationship when they're out of state. They need to be where you are when you establish it. But if you're just doing a follow-up with them, they're already your known patient, and they have a quick phone call issue, that kind of thing, then we do that all the time, right? You may have a patient on vacation in Hawaii and you still take care of them. Can I not sign your standard HIPAA form? And this goes for any practice, DPC or otherwise. Yeah, patient can decline to sign it. That's within their rights. They all assume they have to, but they don't. If I leave the practice, will I get a refund? Hopefully your answer is yes. Things get quite complicated if it's no, assuming you took money in advance. If you didn't take money in advance, then there's no refund owed, right? There's just a final bill that's a little bit shorter. So that's another reason I think it's easier if you bill in arrears.
Regarding that, if you have in the clause to not refund the last month, not prorate the last month, the first month, how about that?
That sounds like a clunkier way to get at it, but I guess you could. Well, let's save it for Q&A. We'll do it again. But he said if you could just, I guess the question was if you could just refund part of the first month rather than the last month because you saved that portion. I mean, that's just a sort of an escrow move that I think is a little bit more difficult to keep track of, but it's possible. Okay, could I rejoin the practice? So I would have an enrollment fee and I would have a re-enrollment fee, and I'd probably make the re-enrollment fee even higher. Because if they leave the practice, then number one, there's maybe already an issue. There's some sort of trust issue or some sort of issue of them simply not wanting to pay the fee. So you want to make sure you want to take them back, and you want to make sure they understand that that's a worse way to do care. Again, there's some recommended reading, and I'm happy to take questions either right now or feel free to email me. Yeah, can you come? Let's use the mics.
Cindy Richards from Charlottesville, Virginia. I've given notice. I'm in the transition process. When I asked my employed hospital if I could keep my hospital privileges, the answer was, you have to reapply and go through it all again. And my question is, what does it buy me to keep my hospital privileges? They're saying I can't moonlight, I can't hospitalist with them anymore at this point. Do I need to keep hospitalist privilege or hospital privileges for any reason?
So are they still allowing you to rotate on your own patients?
Oh yeah.
And
well,
avoid
right
them.
now I can work as a hospitalist too.
So you can avoid. Oh, you're being.
I'm a
to-
family doc outpatient, but I still do hospitalist on the side because I love taking care of my patients. But
Okay, so you're not opted out. You're just being employed as a hospitalist for any number of patients also there.
yes.
Okay. Well, that's another full role, if you will. So if you want to keep doing that, you can keep doing that. That sort of makes sense. The situation I was contemplating was one where you really weren't seeing any patients there, and it was more of a habit of, hey, I've always been credentialed at this hospital. I used to rotate on my own patients. Now I don't, and it's just sort of lingering. So in your case, if you're actually using it, if they're nice enough to you and you're getting along with them, then that's fine to keep it. I'm not trying to scare everybody half to death. It's
They've
more
told me I can't continue to use it when I leave in March.
Okay.
So I am not going to be
Gotcha.
allowed to do any of that. Do I want to?
So I would probably ditch it entirely. Some will offer you courtesy privileges. Even there, that gives them jurisdiction over you for a potential sham peer review case. But the advantage to having that is if a lot of your patients are older and you actually want to offer inpatient rounding, which some DPC docs do. There's one in Arizona who does a lot of it. His entire practice is mostly DPC patients that are older and in and out of the hospital. He's opted out of Medicare, and he's intentionally working that into his monthly membership fee, which is much higher. So that can be done. The biggest, if you're not concerned about a bad peer review problem, then the other biggest problem that typically comes along with it these days is if you want privileges, you have to take unassigned call, which for most DPC physicians means you're doing a lot of free care because you can't sign a DPC agreement under duress, which is going to be all your calls, right? They're going to be ER, that kind of thing.
Okay.
Is that helpful?
Thanks.
Hi, I'm Saj Agarwal. I'm from Tampa. Does the Medicare opt-out have any difference if you do moonlighting out of state, if you moonlight in another state, but the DPC practices in another state?
When it comes to opt-out, it's all federal, and you're either all in or all out.
Okay.
Yeah, there's no LLC game to be played, there's no state licensure issue there, really.
Thank you.
Hi, I have two questions. One was on your slideshow about Medicare, but you didn't actually say it, so I just want to make sure. If you do opt out, you can still order labs and prescribe medications, and they
Yes.
can use Medicare for that.
Yes.
Okay. And then my second question was, could you explain the refund? You mentioned that your answer should be yes, you can have a refund. What exactly do you mean by that?
So if you took money up front from the patient and they want to leave the practice and you refuse to refund it, then you start getting a lot of people against you, right? Patient could go to the papers, that looks pretty bad. Patient could go to the insurance commissioner, especially if you were in a state that had DPC law in the book specifying how you had to do this. Patient could file a complaint against the medical board.
But you don't have to refund, so say they started in January, they quit in October.
Right.
You don't have to refund January through September,
No.
just October.
Right, it would
Okay.
just be whatever the remainder of that time period is, I would argue you should be obligated to refund. And a lot of DPC practices are annoyed with that. They say, well, I took all this money up front on purpose because I do all this work up front.
Gotcha.
And my answer to that is, that's what the enrollment fee's for.
Okay,
Break it up so it's clear what can be paid back and what can't.
so if you're on a monthly withdrawal from their account, then you only refund the month that you're in,
Right,
correct?
if you took it
Okay.
up front. If you took it at the end, then there's no refund obligation at all.
Gotcha.
And you just have a simple prorated final bill, final charge.
Okay.
Which you could easily write off if you just don't want to deal with the hassle.
Okay, thank you.
Thank you, Phil, for all you do for us. Really appreciate it. On the slide you had that had the ACA definition of DPC, it said a qualified direct primary care medical home, and that medical home part makes me worry. Is there a definition for, being an official medical home? Or are we
Medical
supposed to-
home was really popular because it meant whatever you wanted it to mean or whatever I wanted it to mean. And that's why
So
it got
it's-
used over and over in the ACA. The medical home didn't really implicate any further
Like
further
qualified
defining.
doesn't mean you have to meet criteria to be a qualified medical home.
Right, I mean, they did establish criteria, but it was mainly that reference to Washington right there. So that second bullet there, you see they're defining DPC medical home for you. To them, it was all one thing. They just threw on medical home to DPC.
Okay.
And I can't remember if some of that was stolen from Washington State as well. I don't think they used that language. But for whatever reason, medical home was a popular term. So
Right.
instead of just medical home having a definition, DPC medical home has that second definition there.
Okay, thank you.
Phil, I had a quick question. On one of your slides, you had referenced that if somebody has to code something as a physical, that you should probably say, no, you can't. And just sort of a practical point, that many of the health plans out there have an incentive for their employees to get physicals, and they actually get discounts on their premiums if they in fact get physicals. And so what they'll often do is say, look, if I have no proof of a physical, I'm going to pay more for my insurance. And historically, in my experience, an office note does not satisfy that requirement. A prescription doesn't satisfy that requirement. Nothing satisfies that requirement other than an actual claim filed to the insurer. And so historically, what we've done is file a code. If we've performed a visit that I would generally do as a wellness visit, we would give them a form with the code, a wellness code, and we would charge 1 penny for that, which ultimately gets rejected by the insurance company as out of network. And that seems to have satisfied the insurance companies.
I don't have the
Concern.
same concern over that when I compared to other groups that would charge the entire year's DPC for that visit, and then try to get the patient reimbursed for the entire membership, which is really clunky and really risky, and they can get upset then if it doesn't work out. Here, you're just doing them a favor and trying to get them a discount based on the care that was provided, and there's really no financial impact. So I don't have a legal concern with that. I'd have a logistical concern, I guess, if everybody starts asking for it. So again, it's something that maybe you would do as a courtesy, but I wouldn't advertise it.
Hi, I'm Art Talati. I'm in St. Pete, Florida. I'm starting up my own DPC practice from scratch. I was talking with this small private lab agency. They told me that they could contract out a phlebotomist to come in-house part-time basis, like on 1 or 2 mornings, once things are up and running, you know, just for like lab draw mornings. How does that impact with CLIA, right? Or like, do I need to worry about CLIA from that standpoint, or is that something that the lab themselves would have to worry about?
You would need to worry about it.
Okay,
Even though it's their employee, it becomes a burden for both of you then, because it's on your location.
okay, all right, thank you.
Got a question over here. So when you were saying earlier with employers that you should keep it with a membership so that way it's, not an arranged marriage, I have kind of a two-part question in that. One is with pricing, is there any type of obligation? So, like if someone from the community comes in as a, at $70 per month or something, is there any obligation that with that employer it would be the same price, or?
No. You could vary the price. You're actually making me think of a COBRA issue. But if somebody came in from the community and wanted it, you could charge them whatever you want to charge them. Signing something with the employer promising that they're going to have the lowest price would be really stupid and kind of anti-DPC. It's your prerogative to charge what you need to charge for whichever patient. And in fact, with large employers, I'd say they're generally paying a little bit more per month, not less, because they're demanding data and different things from you, and that costs money. So it's probably cheaper to have somebody just one-off sign up from the community anyway. The thing you want to remember, though, when it comes to pricing obligations and, quite frankly, care obligations, is that under COBRA, when a patient is fired from their employment, they have the ability to sort of raise their hand up and say, wait a minute, I don't want to lose my insurance here. I want to pay for this myself until I get another job. And if they had a benefit that was under COBRA, which on-site DPC would be considered a COBRA benefit, then they could still pay that fee and still come to your clinic. So you need to have a mechanism in place to allow them to do that if that happens.
Okay. And this may be a hard question, but just in general for an employer, how much extra per month do you think would be reasonable because of the extra work you might be doing? I know that's such a large ball fill question, but.
Yeah, depends what they're asking of you.
Okay.
I mean, that just varies quite a bit.
All right. Thank you.
I think we have time for one more quick question.
This will be quick. You mentioned that patients can, or that you can get out from underneath CLIA by having the patient go get a self-administered test. Can they purchase the self-administered test from you and do it in the office? Is there any problem with that?
I don't see a problem with that. I think that's sort of that'd be a first case question if CLIA were somehow be annoyed with it, but I don't think it matters where they buy it. I mean, you can sell that just like you could sell vitamins or flowers for that matter, or whatever you want to sell in your office.
Okay. Okay.
About the patients leaving your clinic, your practice, do you still have the 30-day obligation, and how does that factor in with your refunding the fee? So if they opt out like October 14th, do I have the 30-day obligation for them until November 13th? And so in that case, do I still take the fee for part of November, or how does that work out?
So when you notify someone that they need to find a new physician, that's when your 30-day or 60-day or whatever your state kicks in. It's usually 30. And that's not an obligation to necessarily see them. Depends what they're being prescribed. If you were only prescribing them simvastatin, for example, then I'm a lot less concerned than if you were writing Xanax and clonidine, right? Because the risk of stopping simvastatin briefly is pretty low. There's not a withdrawal. There's not a rebound phenomenon. But politically, just the easiest way to handle it is say, look, I can't be your physician for whatever reason. Either you've decided not to stay in the practice or I'm having to have you go for whatever reason, X, Y, Z. And here's your notice. For any emergencies in the next 30 days, I am still your doctor. You can still reach me. And you generally can't charge them for that, even if you were still in the system. You could try to bill their insurance like you usually would have, I guess. But by the time you're doing DPC and you're trying to transition everything out, if you're dealing with this Medicare opt-out and you're in this gray window, then the answer typically is don't take the risk. What's it, $50? What's it worth? So just don't deal with any billing during that time period, is what I would say. It's going to be a very small number of people.
Big hand for Phil. Thank you.
I'm sure Phil will probably stick around